record in the state of North Dakota versus Nikki Sue Melissa Entzel, case number 08-2020 CR 78. Ms. Entzel is present with her Thomas Glass. Ms. Julie Lawyer is present representing the state. We are here for a sentencing hearing. So first, Mr. Glass, I want to make sure that you and Ms. Entzel had the opportunity to read and review both the pre-sentence investigation report and the psychological evaluation.
Yes, Your Honor. We had plenty of time to review those. I'd have to say that I've had pre-SIs that were a lot less difficult to understand. There's so much contradiction and vagueness of I think the only thing really...
Put the microphone a little closer, please.
I think the only thing really verifiable is what can be substantiated. Outside of that, it just seems to have introduced so much opinion and contradictory type things that we know that aren't true, such as using fentanyl almost on a daily basis in 2021 when she was incarcerated with very hard detentions there. I mean, I find it hard to be quite extraordinary. But I mean, outside of those type of things, I guess, the biographical, factual information, we really don't have any disputes with that. It's just...
Well, I guess I need to give you and Ms. Entzel the opportunity to put anything on the record that she wants to dispute in the pre-sentence investigation or in the psychological evaluation. As I understand it, some of the contradictions, according to the individuals preparing those, is based upon contradictory statements that she made.
I understand that, but also there's it's a job to make determinations as well, right? So we may not necessarily agree with them, but they are what they are.
Well, again, I want you to have the opportunity. First of all, you fully discussed both of them with Ms. Entzel.
Yes.
Sir, other than what you said, is there anything on the record regarding either the pre-sentence investigation or the psychological evaluation that you want to specifically address?
No, Your Honor.
Ms. Entzel, you can speak through your attorney if you want, but I want to make sure there's nothing you want to or address with regard to the pre-sentence investigation or the psychological evaluation.
I think it is very much a farce. There was other issues both times we took it with the Zoom capabilities, with them freezing. There's things that addressed, even said in one, will not discuss because of advice of attorney, wasn't to rebate that, and was then, overlooked and said, well, we'll do this anyhow. And said, well, I will not discuss it as advice attorney. When they just would bluntly go over me and say, well, we'll just write this in.
Is there something specific that they wrote that you did not say or that you want me not to consider?
I was asked about the crime, told not to talk. I was bluntly asked continuous co-defendants. I was told not to do that.
I don't recall anything in either of those I don't think they said you said anything. Okay.
And then, like I said, obviously the drug use, I'm incarcerated. There's many little different things where it said that I said it and then it's said again. She did not say. I did go and discuss many things with my attorney, and I said, I have a hard time with a lot of this when it says it in one, doesn't say it in the other. They contradict each other. I said, they should match in realistic lives. Like I said, there was many technical problems when we did both of them with freezing, you can't hearing each other. Things were assumed on both ends.
Anything else, anything more specific you want to say regarding either? I just want
It's
to.
been, like I told him, I said, the big thing is it's been 3 years. You know, and I said to him, I said, for someone to say how I feel or how I not feel, how I act, how I don't act now versus 3 years ago, that's a big difference. You know, I've overcame a lot and had to overcome a lot sitting 3 years. How my emotions are today versus how they were 3 years ago is a big time difference. And so to be judged how I am today and how my emotions are today versus how they were 3 years ago is a really big difference, Your Honor.
Okay. All right, and you'll have the chance to speak again before sentencing as will Mr. Glass. I just wanted to make sure if there's factual information or anything else regarding pre-sentence investigation or the psychological evaluation record you had. So have you said everything you feel you need to say about that? And again, that can be argued more when it comes to sentencing if either you or Mr. Glass wants to do that. So, Mr. Glass, I usually let the state go first regarding its recommendation. I know under Rule 32, it actually puts the defense counsel and the defendant going first, but I often find they prefer to respond rather than go first. Would you prefer me to have the state let us know its recommendation and the basis of that recommendation?
Your Honor, I would just think the more, it seems to be the more traditional way in our district, to have the state present first.
So, Ms. Lawyer, if you let me know the state's recommendation, and I have reviewed the witness or the victim impact statements that were on, and I trust you've been in contact with the victims and will let me know if anyone wants to speak.
Correct, Your Honor. And Deb Entzel and Lori Krause, do you want to address the court today? So with the court's permission, I would start with Deb Entzel and call her to the stand.
Okay. And Ms. Deb Entzel, if you please come forward. And these are statements, they don't need to be under oath as I understand it, because they're just victim impact statements. But if you just come take a seat up there and make sure you speak in the microphone so I can hear you clearly.
If you could start by saying your name and how you're connected to this case or how you're related to Chad, and then you can make your statement to the court.
My name is Deb Entzel, and Chad Entzel was my son. Okay, with that? Can I start?
You can tell me what you want to tell me.
Okay. The hurt and the pain that the loss of my son Chad is unbearable. It is a wound that will never heal. We've always had that reminder of our loss with the empty chair at the family get-togethers and holidays. We will forever miss hearing his crazy jokes and that infectious smile of his. There will be no more phone calls on my birthday teasing me how old I am getting. No more playing hoops or soccer or baseball with his nephews and seeing the pure joy, pure enjoyment on his face when shooting off fireworks at the 4th of July holiday with his family. You have taken all of that from us. Your actions have caused a good man his life and have forever fractured my family. And no parent should ever have to bury their child.
Ms. Entzel, thank you for your statement. I wish there's something I can't even respond because I can't even appreciate how you feel. So thank you for being willing to share that.
And then I would call Lori Krause.
Ms. Krause, if you please come forward.
And if you could also start by saying your name and how you're related to Chad, and then you can make your statement.
My name is Lori Krause, and I am Chad's sister. You took many things away from us. Birthday celebrations, holidays, Sundays just because get-togethers, and most importantly, a piece of my heart. All because you chose money over human life. You sat with my family and cried with us. Fake tears, no doubt, because you had none during the trial. And you lied to us about how much you missed him and let his family plan his funeral like nothing was your fault. We are not victims. We are a network of broken survivors. You may have noticed your side was completely empty at the trial, while Chad's side had more people than space. That's because everybody knows that their world is a much better place without you in it. There are a lot more things I could say about how I feel, but I decided this day is no longer a day of you. It is a day about my brother. This is the day we remember him and what a wonderful person he was. An amazing athlete, somebody who had more friends than I can count, and somebody who most importantly could do anything for anybody at any time. He gave back to his community and was a role model for my boys. Now, because of your selfish actions, he no longer gets to be with his family. Watch his nephews grow up. Graduate high school or get married. I miss the days that I could just call him up simply to invite him to dinner. People will remember my brother as a genuine great person, and I will forever remember and reminisce about the short time we got to spend with him. He will forever be loved and missed. Justice has been done, and I know I speak for a lot of people that wants you to rot in eternity where you will no longer be able to hurt anybody again.
Thank you, Ms. Grimes. Prior to Ms. Lawyer proceeding, I want to make sure there are no other members of Mr. Chad Entzel's family or those who were particularly close to him who want to make a statement. I just want to make sure there is no one else who didn't communicate with the state's attorney's office of their desire to do so. Not hearing anyone or seeing anyone stand, Ms. Lawyer, you may proceed with the state's recommendation.
Thank you, Your Honor. It was difficult to go through this PSI as I said during trial, unless we can corroborate a statement that Nikki Entzel makes, we can't believe that it's true. Because there are so many competing statements, contradictory statements throughout the PSI. In fact, the psychologist even indicated that there were answers that she gave on the initial assessments and tests that when they questioned her about it, she gave completely different answers during the actual psychological evaluation. The PSI writer indicated it was difficult ascertaining basic facts because things that they got for collateral resources, such as that prior pre-sentence investigation, either didn't contain the information or had contradictory information. The psych eval notes that there were difficulties with her honesty and within taking responsibility and her tendency to blame others for her misconducts, and the inconsistent statements again, including, for instance, the frequency for which she self-reported that she was abused by her husband. There were times when they asked about past trauma, she didn't even say anything about being abused by her husband, which again calls into question the fact that he didn't abuse her. There's no evidence that he ever abused her. Ironically, she says she feels angry twice monthly, and it's often triggered by people who are not truthful to her. And yet she has difficulty telling the truth, even in a situation like this. Her brother had told law enforcement that she was notorious for not being truthful and for exaggerating things, and her coworkers said she frequently lied. So that's kind of what we have to deal with digging through this. It's also hard to believe what she says when what she does contradicts what she says. For instance, she claims that she was physically and mentally abused by both of her parents on a daily basis. However, she sends her children there to spend summers with them and holidays with them all the time. She claims to one person that she speaks with her friends Pete Bateman and Nathaniel Goodman on a daily basis, but tells another one it's weekly or monthly. And while she spoke with Mr. Bateman regularly through November 2020, it was once in October 2022 and once in November 2022. And the reason I bring this up is because she advances them as a support system for her, that she's got these two really good friends that she talks to on a daily basis that are supportive and encouraging of her, but she really doesn't have the contacts with him that she reported to the PSI. PSI writer. For Mr. Goodman, again, sporadically throughout her incarceration, about twice a month. And then she claims to speak to her children daily. She does talk to her older son several times a week, but she only talks to her younger son maybe once or twice a month. So the support system that she had indicated through the PSI to the court really isn't there. The other thing that stood out was her self-reported drug use. In 2015, she said she'd never used illegal drugs, has never gone to drug treatment. In this PSI, she claims she started drugs when she was 16. She claims she was using the drug fen-phen regularly from 2000 to 2020, even though it's been off the market since 1997. So it's things like that that make it really hard to know what to recommend or what to do in this case when you can't rely on the statement she's providing. So looking at the factors that the court has to consider in making a sentencing decision, which of course are not limited, but that her criminal conduct neither caused nor threatened serious harm to another person or his property. Well, she killed Chad and damaged the rented home. And so that did, her conspiracy to kill him, her conspiracy to commit the arson, that did threaten serious harm and damage to property. Number two is that she did not plan or expect her criminal conduct would cause or threaten serious harm to a person or property. And again, conspiracy, the whole plan was to kill him and to burn the house down. Number three was that she acted under strong provocation. Again, she claims that she was abused by her husband, but there was absolutely no evidence of that. When she was asked about past traumas during the psychological eval, she gave a litany of things that she had that were traumatic for her, but she never mentioned Chad abusing her. And again, the evidence shows that when Chad was shot, he was laying in the bed. The shot in the wall behind the bed, the pellets were in the wall where his head would have been laying had he been laying in bed. And then she also confessed to law enforcement that she had gone into the bedroom to make sure Chad was in bed sleeping before he was shot. So there is no substantial provocation. Number four is that there were substantial grounds which, though insufficient to establish a legal defense, tend to excuse or justify the defendant's conduct. Again, she claims abuse, but there's no evidence of that. Chad was sleeping in bed when he was shot, and there's no defense to that. Number five is, again, the victim of the defendant's conduct induced or facilitated its commission, and again, there's no evidence of that. He was sleeping at the time that he was killed. Number six is that she has made or will make restitution or reparation to the victim for the damage or injury which was sustained, and there is no amount of restitution or reparation that will bring Chad back. There is no amount of restitution or reparation that will heal his family and make them whole again. She has forever damaged this family. Every holiday when they see his empty seat, every birthday, every Christmas when they remember that that was the last time that they saw him, every New Year when they remember his death, they will never be the same again, and there is nothing she can do to change that. As time goes on, that will lessen, but it will never go away. Number seven is that she has no history of prior delinquency or criminal activity and has led a law-abiding life for a substantial period of time before the commission of the present offense. The court can see her prior criminal history. She's got convictions for fraudulent insurance acts in South Dakota in 2012, theft by insufficient funds in South Dakota from 2014. The records show she was released from probation on that charge in August of 2018. And then the financial transaction card fraud, use no consent in Minnesota in 2014. The records show she was released from probation on that charge on April 17, 2019, which was approximately 8 months prior to Chad getting killed. The defendant's conduct was the result, number 8, of circumstances unlikely to recur. We can't prevent this from happening again. This was her choice, and it's up to her to not do that again. Number 9 is the character, history, attitudes of the defendant indicate she's likely to commit another crime. In looking at the factors that the PSI writer goes through to assess what the recidivism rate is, they came up with a 58% recidivism rate, which is one of the higher ones that I've seen. By comparison, Jose Rivera-Riego, which was a 2018 case, he got life without parole sentence for killing his infant daughter, and he had a 33% recidivism rate. Another one that I handled, Morris Brickle Hicks in 2016, he got life without parole for beating a woman to death. He had a 58% recidivism rate as well. And the West Central Human Service Center assessment indicates that she's got low motivation to make change, which is also concerning for that factor. She believes nothing is ever her fault. It's always someone else's fault. She blames others for the negative aspects in her life. She believes even though she was convicted of this and other crimes, she's done nothing wrong. She indicated in some of those financial convictions that she's got that the victim came back and recanted, so really she didn't do anything wrong, or that it was a miscommunication. But again, no responsibility. And she's taken no responsibility in this case either. She has not displayed any grief or remorse over the death of her husband. And then when you look at the pre-sentence investigation too, they indicated the multiple write-ups that she's received while incarcerated. That was actually on the psychological evaluation on page 4. I won't go through them, but you can see that she's had multiple write-ups. It looks like 8 different types of write-ups that she's received while she's been incarcerated. This also documents her poor follow-through with legal requirements that are given to her when she knows the expectations. Number 10 is that she's particularly likely to respond affirmatively to probationary treatment. Again, that's unlikely since she doesn't believe that she's done anything wrong. She's identified that support system that we talked about, but they aren't really a good support system because she doesn't really maintain the contact with them that she says she does. And she also reports that they all believe that she's innocent and has done nothing wrong, which isn't, again, a good support system for her to start making better decisions in her life. Number 11 is that imprisonment would entail undue hardship to herself and her dependents. In the PSI, again, this was another situation that came up where it's got conflicting information. She reported that she has 3 children in 2 of her 4 PSI interviews, but she doesn't have a daughter. And we know she doesn't have a daughter. Her brother testified on the stand that she's got 2 children, they're both boys. She claims that this daughter is either 27 or 28, depending on whether or not you believe what she said in the PSI interview or the assessment interview. That means she would have been 13 or 14 years old when this child was born. Our investigator followed up with her mother and her brother to verify if she had a child that young, and they said no, she did not. She also reported that this child was either the result of a one-night stand or a 10-year relationship with the child's father. So clearly she doesn't have a daughter. There's nothing that we can do, or there's nothing that we can find that can corroborate the fact that she's got a daughter. Why she would say that is unknown. So she only has the 2 children. One is 21 and one is 15. He's a high school student. He plans to further his education upon graduation, which will be approximately 2026. There is no undue hardship on herself or her dependents with her incarceration. Number 12 is elderly and in poor health, and she'll likely argue she's got poor health. As you can see from the documents that were provided to the court prior to sentencing, she has a laundry list of physical health needs, but she's been in the jail for the last 3 years. They've been able to provide her care while she's been in the jail, not to her satisfaction. She's complained about that as well. But as far as I know, there have been no hospitalizations or any ill effects from that. So poor health is not a factor for the court to consider. She did not abuse a public position or trust, which is 13. And number 14, whether she cooperated with law enforcement authorities to bring others to justice. She did confess her involvement, and it did take 3 interviews, and it did take, I think, 6 tries during that one interview to get her to finally admit what she had done. She's now saying that she wasn't even at the house. She's saying she was never in a romantic relationship with Earl Howard, despite the fact that we've admitted exhibits to show what their relationship was, despite the fact that in September of 2019, we have text messages where she tells him that she loves him with all her heart and soul. She claims that she couldn't have been involved in the crime because she was either walking from the Staybridge Suites to the Kelly Inn, or she was talking to her son, or she was somewhere else, despite all of the evidence that was provided. Again, she doesn't accept responsibility like her co-defendant did. I would note too that the PSI recommendation was a sentence to the DOCR. There wasn't a sentence recommendation for supervised probation to follow. Typically, if they believe that a person should be let out on unsupervised probation, they will include projected or proposed conditions of probation. There was no recommendation for supervised probation or conditions of probation, therefore it appears their recommendation is a life sentence. The written impact statements provided by Chad's mother, Deb, and Chad's sister, Lori, and their oral impact statements all ask for a sentence of life without parole. Based on the sentencing factors, her conduct, her lack of empathy for Chad or his family, her lack of remorse, the fact that she committed this crime within months of getting off of probation on her other offenses, the state's recommendation for count 1, the conspiracy to commit murder, is life imprisonment without parole. We're requesting specific conditions of no contact with Chad Entzel's family, that she provide the mandatory DNA sample and fingerprinting. She pay restitution for funeral expenses, which are part of the PSI's victim impact statement. It's $5,592. Because we're asking for the sentence we're requesting the court waive any of the other mandatory court fees other than the $35 attorney application fee and the $25 victim witness fee. We're also requesting that there be an order that she follow through with the mental health treatment recommendations that are included in the psychological report. On count 3, the conspiracy to commit arson, the recommendation is 10 years, and we're recommending that consecutive to count 1. And the reason we're doing that is if the court is considering anything less than life without parole, that sentence should be consecutive. For count 5, conspiracy to tamper with physical evidence, Class C felony, 5 years, again consecutive to counts 2 and 3 for the same reason. Based on her misconduct and the write-ups she's received while she's been incarcerated pre-trial, she is not entitled to good time credit. That's in statute, but she does have credit for time served, which is 1,137 days, or 3 years and 41 days. Thank you, Your Honor.
Thank you. Mr. Glass.
Thank you, Your Honor. May I approach?
You may. And has Ms. Lawyer been provided what you just provided me?
Yes.
Yes, Your Honor.
I'll take a second to read them. I have reviewed the 2 statements provided.
Thank you, Your Honor. First, it's unfortunate that we're here today. It's obviously a very horrific and tragic and sad case. I would acknowledge that from the defense perspective. As far as the PSI writer and her recommendation, Your Honor, that's just speculation based upon, I have no idea, other than they just said a sentence to the DOC, Department of Corrections. They never made a recommendation for probation or anything like that.
In my experience, oftentimes they don't make specific recommendations. It may
Right.
be DOCR and then probation, but they don't tell the judge how long specifically.
So that's pretty tough to speculate what they were intending with that. As indicated, she's been in custody for, over 3 years. In my experience, I've never really had anybody in county custody more than a year and a half. So this is quite a lengthy period of time to be in a county correctional facility. And if we're going to bang on her for 8 write-ups for being in there for close to 40 months, that's getting nitpicky. That's a very tough situation to be in there. There's continuously different people coming in, coming out, and they're aware of who she is, and so there's always some type of comments and name calling and things along that nature. So it hasn't been an easy stay for her, of course, but I'm sure it's incarceration's not intended to be easy. But just the suggestion that she's been unruly while she's been at the detention center, I think is inappropriate. My recommendation, Your Honor, I guess is based upon the fairness of all the people involved and the co-defendant. The co-defendant got a 50-year sentence, 25 suspended, 5 years supervised probation, and he got straight time on conspiracy to commit arson, straight time on arson, and straight time on conspiracy to tamper with physical evidence, all to run concurrently. Mr. Howard.
Counsel, my notes indicate he didn't get straight time. He got like 10 years, 10 suspended,
Oh, suspended.
5 years, 5 suspended, so that they're hanging over his head for 3 years of probation.
Well, so then he was only sentenced on one of the counts. Okay, I just have written down 50, 25 suspended, 5 years. But in that particular case, he was actually convicted of and pled to one more charge than what Ms. Entzel had. He had pled guilty to arson as well as conspiracy to commit arson. The state at the time, he was charged additionally with the murder, which was dismissed, but he was charged with the murder of Mr. Entzel. I think in these two particular cases, I think a same or similar like sentence would be appropriate. Ms. Entzel obviously has a lot of physical issues. I would argue that there's a lot of mental health issues involved as well. She can get the kind of treatment that she needs in the North Dakota Department of Corrections. They do have facilities and counselors and the appropriate personnel to help her with those issues. I also think it's important that none of these issues really became prevalent in her life until after she met Mr. Howard. If you look at the timeline that the state presented, I don't know if you recall during the trial, when she met Mr. Howard, when they had the meeting for the insurance and the process of how things had started to go in that particular direction. After the event had occurred, she didn't run from the Bismarck-Mandan area. Mr. Howard, he left. Not only did he leave the area, he left the country, went back to Canada, and she stayed. But I think that obviously Mr. Howard pled out to this, so he admitted his role, and I think that he had a lot to do with how things transpired after they had met. I don't know if this particular scenario would have occurred. I think Mr. Howard was somebody that met Ms. Entzel online. I believe there was a manipulative relationship. I think Ms. Entzel is, for lack of a better word, was easily seduced by Mr. Howard and his fairy tale like stories.
Sir, you're kind of just guessing right now. I don't think any evidence was presented at trial as to who seduced who or who persuaded who.
Well, I think
So you're kind of just
we had.
twisting or making up the facts as you hope. I will accept that.
Well, I don't know. We had those text messages. We had them traveling through different towns, going to different stores, looking at homes in Texas.
Right.
So all that was part of the state's presentation.
But none of that indicated that he was somehow manipulating her or that she wasn't manipulating him.
No, I was indicating that a lot of this occurred after she had met him. So,
Well, obviously the actual crime occurred after she met him because they did it. They conspired to commit this.
but I think it's a factor to be considered when you consider the sentence that Mr. Howard got as well, right? So I guess my recommendation to the court is the same or similar sentence that Mr. Howard had received. The 50 years, 25 suspended on count one, and on the other, all suspended for the 5 years supervised probation. That'd be my recommendation to the court.
Thank you. Ms. Entzel, you do not have to speak, but you have the opportunity to. I will let you know, as all counsel know, like Ms. Blair said, you've taken no responsibility. I do not hold against you that you did not testify at trial and that you went to trial. That's a constitutional right you have. I'm not considering that in sentencing, and I'm not asking you to take responsibility now. That's something that's between you and your attorney. So I just want to make sure I'm not holding against you any of that. My decision is based upon what the jury decided, and they're the ones who made the determination of whether you were guilty. So I just want to make sure you understand that. Now, Mr. Glass, I don't know if you've discussed with her whether she wants to speak.
Your Honor, she had put together a written statement. I believe she wants to read it to the court. So,
If you make sure you slide the microphone in front of her.
Judge Barr, I'm reading you this letter today for a few reasons. It gives you a little history of me and what this has done for my life and my boy's life. Growing up, I was taught to be a very hard worker, stay driven, never give up. I became a mom very early in life. The term kids having kids was me. Makes you grow up faster, with life lessons, major bumps in the road. I was in a life-threatening accident while pregnant. Overcame that. That has made some moments very hard, as I have now. Also noted in the PSI. I have now been diagnosed with TBI. With hard work, life went on, more laughs, more new lessons. Me and my son continued to grow up. Had a great job, moved on, new life lessons hit. Got through it all. Right now, new nightmare happens. This can't happen, doesn't happen in my real world, doesn't happen, only happens to other people, not my baby. Everyone says, focus strong, stay strong, move on. So I move on, fast forward, life's great, we're gonna have another baby. But now you have another life lesson to learn. You have cancer, be ready to fight hard. So we fought. I'm here now, and I have to fight for two, not just for me and my other. We fight, and we're still fighting. Then I meet a wonderful man who I think is the most amazing man me and my boys have ever met. We do things. They think he is great to have around on weekends, as we don't live in the same state, so it's only visit on the weekends. Me and my boys are having great talks. They ask for more and more time for Chad to be around. Finally, we all say I do. Things are amazing. But the families are coming, and I get told when my parents are going to meet. My heart drops as I'm told they can't come to visit us at my permanent house. I don't know what to say. My sons and Chad bowl together. Life moves on. Things are great. My youngest son is doing great bowling. Begins to call him dad. The boys start to change. Before I know it, they grow big. I come home one day. A trip is planned, I'm told. A great trip. Trip goes on. Life grows. We move. Yelling starts. It becomes a windfall. People come around, don't know. I come home. I get left. Other things happen. I come home one day. This is the biggest day of my life. A black crowd goes over us. My boys tell me they've been hit. I can't believe it. My happy world has now become unhappy. I don't know what to think. I focus on my boys, focus on my catering, and focus on I need to leave. I get promised it will stop. I don't know what to think. I get promised it won't happen anymore. We'll move on. We'll be a loving family. We get told I have some more issues to go through. I need treatment again. Everything's gonna look brighter. So I say, okay. We keep moving on. I come home one day. My boys are a wreck. They've been locked in their rooms all day. I say, why? They say, we need to leave. We need to leave now. I get told. I say, that's it. We're leaving. I will look for another place. This becomes the worst night of my life. My heart and my soul are broken. My boys are hurt. I don't know what to do. I gotta leave. Everyone knows that this can't really happen, but everybody knows, and I'm asking for help. Your Honor, I have been through all kinds of abuse. Now my boys have been through it. I have to live through this every single day. Nobody can tell me what I have to live through. Nobody can tell me the pain I have to live through every single day. From the day that I got told that to the day I started saying I need to move out. To the different times people said that they would be there to help, to who really helped and who really didn't help. Then to be told in different sessions, I don't feel enough. I don't have enough. So here we are. We're getting ready to go to trial. I'm a wreck. It's been 3 years. I've patiently waited. Every time I get ready to go to trial, it hasn't worked out. I've patiently waited. But here we are. We're going to go to trial for real this time. My heart's a mess. I get told I need to take a plea deal. It's going to be this way. I don't want to. I want to have my chance. It's my right to go to trial. But I get told that if I don't, the prosecutor's going to make sure I sit and rot and my kids never get to see me again. This isn't right. I feel like I should have a right to go to trial. And that's the right I have along with my boys. My boys say that they need this day as much as anybody else. Judge Barr, I've had to live with the loss, not only for myself, but the loss for my boys also. Nobody knows the loss I live every single day, not just with Chad, but with the loss of my boys. I don't have my boys. I don't have anybody else. I have been incarcerated for 3 years. I have learned to deal with a lot of loss. There is nobody in the jail systems to really help us. I deal with the loss independently. I don't have other people to contact. Yes, I have family. Yes, I have other people. Jail is very expensive. Calls are very expensive to deal with loss. Do I talk through friends with my boys? Yes, I do. My boys are also in school. It's not possible to talk to both of them every day. But Your Honor, I do miss them. I miss a lot while I'm in here. I'm asking you to please understand the losses I do also have. I miss a lot. I have great losses. Nobody can write on a piece of paper what they think I have for a loss. That is not a fair way to put me on a piece of paper. So I'm asking you, Honor, to please have consideration when you do sentence me. I don't think a piece of paper should determine someone's life. Thank you.
Thank you. Mr. Glass or Ms. Entzel, anything, other information you want to present in mitigation of punishment or other information at all that you want me to consider in determining a sentence?
No,
Ms. Entzel, anything further? Situations are always very difficult. There are a number of factors to consider. And I won't go through those in the same order that Ms. Blair did. But the court considers the nature of the offense and the defendant's role in that offense. Of course, this is one of the most serious offenses that there can be. Conspiracy to commit murder, not just a conspiracy to commit murder, but the murder was actually committed. There's actually a loss of life, and the jury found, and the evidence showed that Ms. Entzel was actively involved in planning and possibly executing that. We don't know who actually executed the plan. But as noted, the harm is one of the greatest harms that there can be, a loss of a life, both that person's, the loss to that individual, as well as to the family members and friends who would never have that opportunity to have that individual, Mr. Chad Entzel, part of their life. So the harm is extremely significant. The impact on the family, the community. Again, I've heard Ms. Entzel and Ms. Krause testifying. I read the victim impact statements previously. I can't fully understand the emotions that they are going through. I can't quantify that, as I'm sure they can't even fully express it in the impact of that loss has them on each day. The vulnerability of the victim, in this case, We don't have someone who's a minor. We don't have someone with a disability. We have a spouse, which in a way is maybe vulnerable because you trust your spouse and that they're going to treat you with love and respect. In this case, there's a weapon, a shotgun used, as well as an attempt to burn the house and the body. So that's an aggravating circumstance. We have the criminal history. No violent offenses like this in the past, but as Ms. Boyer pointed out, the 2012 Fraudulent Insurance Act, 2014 theft by insufficient funds, the 2014 financial transaction card fraud, and that Ms. Entzel had only been on probation for under a year at the time the new offense was committed. Court notes in response to Mr. Glass's assertions that kind of Mr. Howard may have been an important role in this, as those prior crimes kind of refute that some. She didn't get involved in those crimes with Mr. Howard. She was doing illegal things and blaming other people back in 2012 and 2014. Bail and probation. She wasn't on probation, so I don't know how she would do on probation. As far as the write-ups, I don't consider that significant. I think anyone in custody at a detention center for that long will probably have some write-ups, so I don't take that as a significant factor. Recidivism, as the pre-sentence investigation found, a 58% chance of recidivism. This is very significant to the court. And even the statements, again, I don't expect Ms. Entzel to make any admissions that she has a right to remain silent, and I do not, but everything's focused on her. And that's what the PSI found, that's what the psychological evaluation found. It's how I'm suffering. It's not how the family's suffering. And even without admitting, there could be some acknowledgement that this is a major thing for the family. Restitution is impossible to make any type of restitution in the life of a person. Age and health, Ms. Entzel was 41 years old. She should have been sufficient maturity to know what she was doing at the time she committed this offense. I recognize her poor health, but that's not a reason not to be incarcerated. Her statements are inconsistent. I have mental health issues. I don't have mental health issues, as both the pre-sentence investigation and the psychological evaluation noted. It's very difficult to know what is true, as I think the investigators found from the evidence that we saw at trial, because her story is constantly changing depending on what she wants to say at that time. Position of trust, she wasn't a fiduciary or anything, but again, she was a spouse who you would hope the other spouse could have some trust in. Mitigating circumstances. I have seen no evidence that Mr. Entzel abused Ms. Entzel. Nothing was presented at trial. It's just her self-proclaimed statements, and those have changed today. At least this is the first time I recall claiming that he abused boys. And so it seems to be a never-changing story, depending on what fits her circumstances and what she thinks will help her. But I don't recall any statements at trial that the boys were abused. It was just you and him stalking you, following you to the bowling alley and things, which were also inconsistent with other things that were said. So I see no mitigating circumstance of being abused or provoked into causing the death of Mr. Entzel. And even if there was some abuse, there's many options short of taking someone's life. I think I already noted that rehabilitation, the chance of recidivism, 58%. Hardship, one of the sons is a minor, but any reasonable sentence, he will hit the age of majority before Ms. Entzel gets out. So to use him as a reason to diminish punishment makes no sense to me, and that would be a very short sentence for for taking a life, to think that she would be out prior to the 15-year-old turning 18. I have taken into account the sentence of Mr. Howard. There are a number of distinguishing factors there. I believe Mr. Glass explained the sentence there. First of all, that was through a plea agreement. In a plea agreement, the court has two options. Accept the plea agreement, whether the court likes the actual sentence or not, trusting that the parties have reached an agreement that is fair and appropriate based upon the evidence, and oftentimes things that the parties may know that the court does not know, such as the strength of witnesses and other things. Or the other option is to reject it and force the matter to go to trial. When the court's presented with a plea agreement, the court doesn't always get to impose the sentence that the court may feel it is appropriate based upon the nature of the admitted violations. Mr. Entzel, in my recollection, also had no criminal record, unlike Ms. Entzel. Mr. Glass noted he went to Canada, that he did voluntarily return on his own, so it did not appear that he was trying to avoid law enforcement. And I'll note that at the time of sentencing of Mr. Howard, Mr. Entzel's family supported the plea agreement in order to bring the matter to resolution as to Mr. Howard, and the court significantly considered that in accepting that plea agreement. If the matter had gone to trial, I don't think there's any way I would have imposed the sentence that was agreed to in the plea agreement. But deferring to the state and the defense attorney, understanding they are aware of information, and seriously taking into account the victims, Mr. Entzel's family's support to that, the court did accept it. So I do not find Mr. Howard's sentence as precedent. I am not going to award the same or impose the same sentence in this case. To me, my decision is whether it's life or life without the possibility of parole. Anything else, I believe, would be a grave injustice. And that's where I'm deliberating at this point. I'm comparing it to a case I did a sentence in last year with life without parole, where the individual was slightly younger, but he had a significant larger criminal history of over 60 convictions, had been incarcerated multiple times and violated probation. I think it was about 5 times, and it hadn't any opportunities for treatment. And in that case, because of the significant opportunities he'd had to correct his behavior, to receive treatment and stuff, the court did impose life without the possibility of parole. Both of those, that case and this case, each resulted in the loss of life, under different facts, of course. And I also appreciate Mr. Entzel's family. I think many people feel that if someone takes a life, they should never have a life of their own. They should simply be locked up and not have the pleasure of being free at all. I understand that sentiment, and I know there's many people who feel that. I also tell the parties I'll give very little weight to the 2 letters. And neither of these people testified at trial. There was no evidence, no statements of the children being abused or any of that information until today. So the court finds that of very little weight. On count one, considering all the factors, and as I think everyone can tell, trying to weigh those factors and determine what's most fair and appropriate, I am going to impose a life sentence. I will not do that without the possibility of parole. As significant as murder is, there is the possibility that through proper counseling and other help, that Ms. Entzel may be able to be released down the road and be able to be a productive member of society. The fact that it's life without parole does not mean she will be released. Victims' families will have the opportunity to participate if they want in sharing their thoughts about her being released in the future. And under the law, she has to serve a minimum of 85% of that sentence, which I will address in a minute. And so for count one, life, or required DNA and fingerprinting, I will order the restitution of $5,592, waive all fees except the $35 victim witness fee, the $25 court-appointed counsel fee, require participating in mental health treatment. And Ms. Lawyer, was it 1137 or 1037 days credit?
1137, Your Honor.
You get credit for 1,137 days. On count three, I am going to impose 10 years all suspended and 3 years of probation. And on count five, 5 years all suspended with 3 years of probation. The purpose of that is for if Ms. Entzel gets out on count one, she will be on probation and have the possibility of 15 additional years if she does not keep those conditions of probation. So that will help hopefully protect the public and ensure that she complies with any mental health counseling or anything else she needs, if she needs it at that time. Ms. Lawyer, since I'm suspending it, so we have that time hanging over her head, does it really matter if it's consecutive or concurrent?
It doesn't at this point, Your Honor. It would on a revocation.
Yeah. So I'm going to make them consecutive. All three counts are consecutive. Again, 1,137 days of credit. I'm asking the clerk to provide counsel Table A of the 2019 United States Life Tables under Administrative Rule 51, Section 2. If there's a life sentence imposed, the person has to serve a minimum, under the law, the person has to serve a minimum of 85% of the sentence. Well, what is a life sentence? In order to determine that, under Administrative Rule 51, Section 2, the court has to look at Table 1, United States Life Tables 2019. On the third page of what I have handed to Ms. Lawyer and Mr. Glass, under the age of 40 to 45, which would be Ms. Entzel as I understand it, and to the far right, non-Hispanic white female, I see that her life expectancy is 42.7 years. As I calculated it, 85% of that is 36.29 years, or 36 years, 105 days. So in the judgment, the minimum that she will have to serve is 36 years, 105 days. I will give both counsel the opportunity to review that, and by close of business Tuesday, let me know if you disagree with my calculation, unless you've already looked at this and know.
I have looked at it, Your Honor, and I agree.
Okay. Mr. Glass? I looked at this before in case I did impose life without parole. Didn't know what I was gonna do, but I wanted to be prepared if I did. So do you agree with that calculation?
Yes, Your Honor, I'm familiar with the table.
So the judgment will include that. And so although this would be quite down the road, I do need to review Appendix A with you, which will identify the conditions of probation. Under number 1, you may not violate any criminal law or ordinance, whether state, federal, county, city, or tribal. Under 2, you may not use or possess any type of firearm, destructive device, or dangerous weapon. Under 3B, you may not use alcohol in excess. 0.08% is presumed to be in excess. 4, you may not use any controlled substance except as prescribed. 5, you may not use or possess surveillance or counter-surveillance equipment. In number 8, you may not willfully defraud a urine test administered as a condition of probation. Under 9, you'd have to report to the probation office within 24 hours of release. Under 10, you have to stay in contact with the probation officer as directed. You have to get permission prior to changing your address, and you have to promptly let the probation officer know of any change of phone number or employment. 11, you have to allow your probation officer to visit your place of employment and your residence. Number 12, you have to allow your probation officer to search you, your place of residence, your vehicle, or other property. 13, you need to continue with or seek appropriate employment or educational opportunities. 14 is testing for the use of alcohol or drugs. 18 is a $55 monthly supervision fee. The 20 is the fingerprinting. 21 is DNA. Under 22A, if requested, you would need to participate in cognitive restructuring. 24 is participating in intermediate measures. I'll explain that a little bit more in a minute. Under 25, you have to have written approval to associate with known felons, drug users, or traffickers, or to leave the state of North Dakota. Under 26, if there are any, you have to comply with any conditions of mental health treatment, if there are any in place at the time you are released from the Department of Corrections and Rehabilitation. I want to make sure you understand 24. Part of probation, if you violate the conditions of probation, your probation could be revoked. If your probation is revoked, you could be resentenced to that 10 years and that 5 years. So you could be resentenced to 15 more years. An intermediate measure, sometimes, typically, probation will give you the chance to try to cure your violation and to do something to stay on track. So that's why you should participate in that if that occurs. But I want to make sure you understand that probation can be revoked and you could be resentenced to 15 years if you violate the conditions of probation when you were on probation, if you get on probation. Do you understand that?
Yes.
Mhm. And I want to just, to Mr. Entzel's family, I know you may be disappointed in the sentence that it's not life without parole, but as noted, that doesn't mean she will get out in 36 years with the credit for time served. That is something that may happen depending on what's determined based upon how she is doing and whether the board believes that she would be safe for her to be released to the community. So I just want you to understand that it's not a minimum. I mean, the maximum is life. The minimum is the total of 36 years, 105 days. Ms. Lawyer, did I cover all aspects of sentencing from your perspective?
Yes, you did, Your Honor.
Is there anything that I should have addressed in this hearing that you were aware of that I missed?
Just the notice of appeal.
That will be next. Okay, Mr. Glass, did I cover all aspects of sentencing?
Yes, you did, Your Honor.
Okay. Anything other than the notice of appeal I have not addressed that I need to address?
Not from the defense, Your Honor.
So, Ms. Entzel, I need to notify you of your right to appeal. You have the right to appeal And if you are unable to pay the cost of an appeal, to apply for appointment of counsel for purposes of appeal. Under Rule 37B, a notice of appeal must be filed with the court clerk within 30 days after the entry of the judgment or order being appealed. There's additional information regarding the notice of appeal that can be found in Rule 37, and I trust you can just discuss that with Mr. Glass if you need, or if you request court-appointed counsel to represent you. So just want to make sure you understand those rights. Anything further, Ms. Lawyer?
No, Your Honor, thank you.
Mr. Glass?
Oh, yeah, thank you.
All right. Thank you, everyone. We'll close the hearing.